Hi, my name is Mathew Thomas Philip, founder of Thomas Philip. I am happy to have Sarah, Nicole, Jocelyn, and Jane joining me today on law firm management. Is this a series that we're doing to try and share some of the firm management issues or issues that are affecting the legal profession so that we can have more discussions about it, and with those discussions, perhaps a momentum towards improving the lives of lawyers and law firms. So today, I want to talk about money and talk about, just before I start, about the topic, which is contingency fees. I want to give a tip to young lawyers because this law firm management series is more tuned towards young lawyers who are thinking about setting up their own firm or planning to set up a own firm or already in a own firm. One of the tips that I like to share is about how you plan money, and the easiest way to try and pace yourself in terms of money is to determine how much net profit that you want to make. That so say for example you're a sole proprietor and you say you want to end up 100,000 ringgit at the end of the year in your pocket in order to sustain yourself after costs. So once you determine that figure, you add on, of course, your cost element. These are very basic stuff, but a lot of lawyers don't go through this very basic regime. And let's say you find out that your cost is 100,000, you find out that the revenue that you need to generate is 200,000. And I have a simple formula that I want to share. What I do is I say there are 200 good days in a year. So if you need to hit a gross revenue target of 200, then your daily target is going to be, although there are 365 days, in practice, you'll have 200 good days. So it means that you need to hit 1,000 ringgit a day in terms of your gross revenue. And so they'll give you, and if you're a sole proprietor, you can basically work out what the firm should be generating on a daily basis. So using that simple formula, working out your target, dividing it by 200 will will give you your day formula. And from the day formula, you can work out your week. So my tip to everybody is that it is impossible to achieve your target unless you know what your daily target is and your weekly target is. Because human beings can operate very easily on daily and weekly, but beyond then, they'll start losing control. So that's my tip of the day before I start this week's topic and conversation. So, first question by Nicole. You have a question?
Hi, Matthew. So we know that the Section 112 of the Legal Profession Act 1976 expressly prohibits contingency fee. And the reason for that is because it might lead to corrupt and unethical practice. Do you agree with that?
So I can't agree to that. I think there's a body of thinking that believes that if a lawyer is driven by a contingency fee arrangement, then he is going to pervert the ends of justice. He will want to win at all costs in order for him to secure that contingency fee arrangement. I think it may be true to a certain extent, but I think in today's world that idea needs to be visited again. So I think the premise of that philosophically, historically may be valid, but I think we've evolved in such a way where information is readily available. So the the um, the idea of accountability and being transparent is easier. So I think the time has come to revisit those assumptions that if you do contingency, the lawyer is more likely to go be unethical. So, but at the same time, I'm not saying I've got a solution to the fact that it may have a propensity. All I'm saying is I don't think we can stop the discussion as contingency is bad, so we will not allow it. So, Nicole, does that answer your question? Do you have a...
Yes. So, on that basis, right? So, if contingency fee were to be allowed, and in commercial sense, in commercial litigation, then of course we know that it will involve usually a large amount of sum. So, what do you think then will be a fair share between the lawyer and the client if the case is won?
So I think the contingency fee arrangement should, if it's going to be allowed, has got to be a reflection of what or the ordinary fees is going to be with a premium. So for example, if the normal fee is going to be 100,000, then in a contingency fee arrangement, it may result in a premium being attached. So it says, if you pay me the $100,000, that's what you normally would pay. But since you do not have the $100,000, I would charge you a contingency fee of, say, $200,000, which represents twice the amount of what you ordinarily would have paid. So there's a measure, there's an easy measure. So in that sense, the client can do their own calculation to say, I've got an option. Come out $100,000 or end up paying double that in the event that it is recovered. So I think the measuring of that is possible to regulate the measurement of that, or to so that it's still subject to the rules that you cannot be exorbitant, right? So it will depend on the value of the claim, the complexity of the claim, the same things that goes into a bill. So if a lawyer actually charges something that's extortionate, the court can actually struck it down because it's subject to taxing. So the court says this is extortionate. Even where there's an agreed fee, the court can regulate that and say that's extortionate, because the relationship between a lawyer and his client is such a nature that the contract between the client, even though it's in written form, is open for scrutiny by the courts. So I think that there is a possibility that we could come up with a structure that is acceptable. So maybe the opening of door would be that if you're charging a contingency fee, you're allowed to charge a certain amount above what you ordinarily would have charged to cover the risk that you have actually taken. So that may be one way to deal with it. There's so many ways to deal with it, but that's one way, so that you don't have a complete windfall that's unrelated to or disproportionate to the fee that would have been paid. Because I see the contingency as providing an avenue for access to people who didn't have the money, and compensate the lawyer who took the expense of that case, right? There's an expense. So that's how I see it. Of course, the reason why I'm saying that is I think these are things that we need to discuss. So we can't say, hey, Lord Denning said this. So Lord Denning said that in 1963, right? That's before I was born, right? Like 1963, yeah, some things don't steal. I mean, the 10 Commandments, or whatever religion that we have, everything is kind of cast in stone. But here, where there is room for discussion, there's room for talking about it. So I think it's time we had a discussion about all these rules, because I think there's a lot more other stuff that is pushing lawyers to do unethical things that are absolutely unrelated to contingency agreements or some of the other rules, which, so I think if we are looking at it, it's a constant thing. We got this rule up for review. What do we do that? Lord Denning said that public policy is against championship because it's tempting nature for lawyers to do it. It will inflame damages, suppress evidence with cases. Let's look from 1963 to now, right? It's happened even without contingency agreement. So that's my answer. I think it's time to revisit all these assumptions.
Right, thank you, Matthew. That's all from me.
Sarah, you have a question.
Yes. So earlier you said that in order to determine an appropriate fee that the lawyer should charge a client, you have to consider sum of claim, complexity of the claim. So do you think the prospects of succeeding in a claim is a relevant consideration for lawyers when determining the appropriate fee to charge their clients?
No, I don't think so, because I think number one, you can't bring a case that is bound to fail, because that's an abuser process, right? You can't bring a case that's definitely bound to fail such that it's an abuser process. It's a nuisance case, so you can't do that. So the assumption is every time a lawyer grows his case, the lawyer actually believes there's an arguable case, right? The prospects of success will determine on the facts that are presented, on the evidence. And I always say that we are presenters, right? And we're not God to know what actually happened. We're not saying the truth is out there, but it's my job to present the most logical presentation. So I think the prospects of success is not a relevant consideration. However, people can talk about this is an arguable case, this is a difficult case. So difficulty of that case relates to complexity, right? So I would think the charging will go to the complexity of the case. Again, it goes back to what would the ordinary fees be? And what is the premium? Give me an example. What if we said that you can charge a contingency of 50% premium over ordinary fees? Let's say we regulated it that way. In that situation, do you think that everybody is going to say that that is going to drive a certain kind of behavior when the premium is, say, 50%? That means if you would get 100,000 and be regulated and said, but you can charge up to 150,000 contingency. So those are things that needs to be looked at. Things need to be regulated. However, if a lawyer would have ordinarily charged 100,000 and then his contingency agreement is 2 million, I think it's wholly disproportionate and extortionate. It doesn't reflect. So anybody, for example, the business people who undertake exploratory work, the people who go and mine, look for gold and spend money, and there's a certain payback, right? So there's risk taken. So that's got to be proportionate risk assessment. So I think in terms of calculating, it cannot be the prospects of success. Well, of course, it's related to the complexity. You know, I'll put it that way rather than the rate. Yeah.
Yes, thanks, Matthew. You did mention that the proportionate. This is a very I would say a fair safeguard against people abusing the contingency fee, legalizing this arrangement. Do you have any other safeguards in mind?
The other safeguard would be disclosure, so that perhaps there's a keeper of contingency agreements with the Bar Council, so that Bar Council will say, if you have a contingency agreement, that has to be put with the Bar Council, and it's scrutinized or open for scrutiny with the Bar Council. it probably requires some form of effort, but I think it's possible. So a lawyer wants to enter a contingency may have to go and register with the Bar Council. I'm entering a contingency agreement on this case, and here's a copy of it, and they take custody of it, and then find a way in which confidentially is secured, but at the same time there's some scrutiny. That's one example.
Last question for you, Matthew. So, notwithstanding the express prohibition against excessive fee set out by the Bar Council rulings, there may still be firms overcharging their clients. So, for example, there may be a firm who is charging their client 300,000 just for a security for cost application. So, do you think?
Right.
No. But do you think legalizing the contingency fee would help to address this issue of overcharging?
No, I don't think this is going to help this case. I think that information about legal fees is not forthcoming and it's not transparent. And the reason why it's not transparent is we got another prohibition, which is that lawyers are not allowed to advertise their rates. It's part of the advertising, so you can't advertise and say to do an injunction, this is what we will charge for it. Again, I don't believe in that rules. I mean, the rules are there, so we have to follow them. But personally, I think those rules needs to be revisited as well. And there are two forces at work. One is, the fear is that if we start advertising, then there's going to be devalue of the profession because, people start advertising, I'll do your injunction for $5,000 or $10,000. How would it affect the profession? Again, I think the problem is that we are already always focusing on the problem. Oh, this is the problem, right? But there's not enough emphasis on, okay, this is a problem. How is it affecting the clients? How is it affecting lawyers? And what are the potential solutions for that? So I think that's where no discussions goes beyond, this is what the problem is going to be. But nobody is going for, okay, yeah, we recognize this is a problem. How do we mitigate it? How do we do it? It takes time and effort to investigate. So for example, if it's possible for lawyers to advertise their rates and regulate it, then you will find that you will not get that situation because the client will know, the client will be able to say, hey, hang on here, an interlocutory application for security for cost shouldn't be costing 300,000, right? Because there's a range that we can ask. Even if you take the most competent lawyers, it cannot be 300,000 for an interlocutory application. But the client will not know that unless he has access to information. So given that we ourselves said we can't do this, we can't advertise it, come from advertising, we create other mischief which we never solve, right? So I think we need to look at it and say, well, how do we do this? How do we make sure that we don't be a pasar malam situation? I think with the best intentions of the Bar Council, it is inevitable the way the world is going to move, that's the direction it's going to take. And it's better we be ahead of the curve by thinking this is going to happen, we better regulate it in a good way. Otherwise, it's going to have a black market. So now that's why you see that there will be everybody just going out there and saying, I'll give you an example. You can't stop a non-lawyer from actually saying, hey, Thomas Philip charges this much for this. You can't stop it in this internet world. And then the Bar Council said, hey, Thomas Philip, did you get this guy to talk about it? He said, I know, he's a happy customer. he talks about the fact that he got very good fees. So we have to think about that you can't regulate somebody sitting in Indonesia or Singapore talking about the law firm in an indirect way. So all this stuff is going to come. And I think they really need to look at it and regulate it. Okay.
That's all from me. Thanks, Matthew.
Okay. Who's next? Jean, you've got a question for me?
Yep. Okay. Tying into what you said earlier, do you think that if contingency fees were actually was actually made more known to clients and customers, and they were given more information on the legal fee structures, this will provide more access to justice? What are the ways or methods that you can think of in providing these methods for clients to have more information about the fee structure that's provided?
So at this point in time, contingency fees are not allowed. And so it's I'm going to hypothetical situation. So I imagine that the moment it's opened up, there's some regulation and there's some guides about the fact that perhaps before you enter into contingency agreement, you will have to give a breakdown of the actual work and the estimate cost, right? So that the clients don't get carried away. The clients are given an option. So I think that's going to be mandatory. The clients will say, oh, I don't have to pay anything, but I pay 25%. 25% of 100 million is 25 million for sending a letter of demand. Cannot be the case, right? So that's meant with proportionality to the situation. So I think first step is, how much do I have to pay if I had the money to pay? This is how much you're going to pay. And because I don't have this money, I'm now opting for a premium model because the lawyer is carrying the risk, right? So I think if contingency is allowed. Second issue is that even the estimates, how do the client determine what the estimates are? Again, that's why I'm saying that the idea of not allowing lawyers to regulate needs to be, talk about their fee rates, need to be looked at. So for example, what is wrong with disclosing, if you're doing hourly rate, disclose the hourly rates of your lawyers on your website, how much the lawyers cost, say no. So from that basic model, let's say, Sarah, you advertise at $250 an hour. Most clients can calculate, right? So they can say, hey, Sarah, I know you're $250 an hour. I got this problem. How much are you going to charge me? And you're going to say, oh, I'm going to charge you 1,000 ringgit. Now, they already know one part of the equation, right? 250, and let's say you're charging on an hourly rate. They now can be guided, hey, Sarah, why does it take you 4 hours? Because it's like, you're 250, right? You're going to charge me 1,000. Why does it take you 4 hours to do this job? At least they can question the sum. Right now, it's very difficult. The things the client can do is they can shop around. They can say, oh, this lawyer is charging me. Can you give a quote? I think it's not that difficult to be able to be transparent about what resources are going to be put in, at what rates, and the clients don't want an hourly rate. You start from a hourly rate, which is the easiest. You'll say, for example, this work will take me 10 days lawyer days. One lawyer day is 1,000, let's say, so it's 10,000. There's some clarity. Why do you take 10 days, right? I don't want you to take 10 days. So let's start from, it's easy to discuss. It's not working for us because with the clients shopping around, they're focused on not the quality and the time that's been put. They're focused on what's the cheapest one I can get. So it's not working for us. So that educating the clients, nobody wants to be ripped off. Clients don't want to be ripped off, right? But if the clients are educated, then they will see that at the end of the day, oh yeah, this is fair and reasonable. But there is no measure right now. They're just comparing off another lawyer. So they call a guy, okay, I want this done. How much? Okay, how much? But they will not know the measure that these fellas took, the measure that you took. That's something that we can do by education. Okay. Next question.
This is a bit of a sidetrack. This is in relation to the access to justice, because for contingency fees, it's framed in a way that if the lawyer doesn't win, you don't have to pay the fee. This allows less financially able clients to somehow get access to justice. And what do you think is the balance that has to be struck between morality and this access to justice per se?
So right at this point in time, we know there's a parallel, it's almost like a parallel economy. So while the Bar Council will say you cannot have contingency agreements, the rules prohibit contingency. The practice is prevalent, and so I would opt for saying that it's not going to, it's not, the regulation has not stopped this behavior. So the behavior is driven somewhat by demand, and you're right, a lot of people would not get access to justice, right? For example, if we said we're going to send lawyers who charge contingency to jail, we'll hang them, right? The result is a lot of people will not have access to justice. So we know that, right? Because lawyers are taking the risk that they will not get caught, and therefore they provide this almost like a parallel economy. So knowing this is taking place, wouldn't it be better for us to look at how we can shape it along? So I certainly believe that more information, more transparency, certain areas of clients, I think that it just needs a lot of study into it. I think it's just one, oh, this bad, that's it. I don't think life is like that. I don't think everything is like, oh, this is bad, therefore that's it. That's where I feel it's just everything is bad. Oh, this is bad, so we won't do it. This is bad, we won't do it. I think that we need to look at a bigger picture. It requires a little bit more investigation. So I'm one for saying, okay, I don't charge you, do it pro bono because you can't afford it. But at the same time, how much of that can we do, right? So we can have like pro bono, I don't charge you, give access to justice. And another one is contingency, providing access to justice in a regulated way. Okay, without the clients being exploited. And that's the key thing. If the client is not exploited, the client is happy, then the only remaining thing is lawyers is going to fabricate evidence to win the case. I'm not entirely sure that, I'm not entirely sure. I think you regulate the 10% who's going to do it rather than the 80 who's not. Okay. Is that it? That's it for today. Thank you so much for joining us on our discussions on law firm. It's just to share ideas. If you have anything that you want to hear from me on the challenges of running a law firm, some ideas that affects our profession, I'm happy. My number is 017-888-7772. Happy to WhatsApp. Easiest way to communicate. Thank you very much and have a good weekend. See you next week. Bye-bye.